Welcome back to Counting to Five, a podcast about the United States Supreme Court. In this episode, I'm going to talk about the court's decision in National Association of Manufacturers v. Department of Defense, which was issued Monday, January 22nd, 2018. Now, this case, it's not one you're likely to have heard of. It's not a big hot-button political issue. Instead, this is a procedural case. It's a case about how certain types of legal actions need to work their way through the federal court system. But it's an interesting case because it illustrates the real-world importance of clear procedural rules so that litigants can know where they're supposed to file certain actions, how these actions are going to play out in the court system, and shows the problems that come when you have a broken rule that is unclear and people don't know what they're supposed to do. The issue in this case, it comes from the Clean Water Act. Now, the Clean Water Act was a major environmental law that dates to 1972. It was intended to reduce pollution in U.S. waterways and set water quality standards and things of that sort. Now, the Clean Water Act, by its terms, it applies to, quote, the waters of the United States. So the question is, what are the waters of the United States? What does that cover? Now, it clearly covers things like major rivers, but the further out you get from that, the less clear it is. Now, once you go from the major rivers to streams and tributaries, and then to things like drainage ditches that empty into a stream, or marshy areas, or seasonal ponds, or other things of that variety, which of these come within the scope of the waters of the United States? Now, that's been litigated for years, and there have been several cases that have gone up to the Supreme Court that have dealt with whether the waters of the United States applies to certain types of water, including a case about whether seasonal ponds in an abandoned sand and gravel pit can be filled in, or whether they qualify as waters of the United States, or whether homes can be built on low-lying marshy areas near the shores of a lake. If the lake is a water of the United States, what about this swampy area near the lake? In 2006, the court had a case called Rapanos v. United States, and this case was about whether wetlands lying near ditches or man-made drains that eventually empty into traditional navigable waters, whether those wetlands are waters of the United States. And that case resulted in basically a three-way split on the court without any clear majority opinion about how waters of the United States should be defined. So this is an issue that's been out there for a long time and has resulted in lots of litigation. Now, in 2015, the EPA and the Army Corps of Engineers issued a regulation defining the waters of the United States. Just giving a more precise definition of what counts and what doesn't count as waters of the United States under the Clean Water Act. Now, the EPA is obviously involved because they're the major federal environmental agency, and the Army Corps of Engineers is heavily involved in water regulation. They control locks and dams and reservoirs and flood control systems and things like that, and they're involved in anything water-related. They play a large role. This rule that was issued in 2015 has come to be called the WOTUS rule, WOTUS just for Waters of the United States. And by many in industry, it was considered an aggressive assertion of authority over a lot of types of water that many believed should not be covered or under the Clean Water Act. This resulted in many court challenges all across the country. Numerous actions were brought. So this is where the problem comes in this case that's come to the Supreme Court. In general, challenges to EPA rules are brought in the federal district courts. Those are the trial-level courts in districts all across the country. And that's where a challenge to EPA rules would normally be brought. However, the Clean Water Act carves out 7 categories of legal actions that, instead of going to the district court, bypass the district court and should be filed directly in the Court of Appeals. And what's more, if there are multiple cases filed on the same topic in different courts of appeals, they will be consolidated together into a single court. And the idea here is that there are certain issues that are important enough that it's good to have the efficiency of getting to the higher level court faster, and also the national uniformity provided by having a single court of appeals deciding the issue, regardless of where it's brought in the country. However, the argument here is about whether the challenge to the WOTUS rule, so this challenge to this rule defining the waters of the United States, falls within one of those 7 categories that requires it to go to the Court of Appeals, or if it's outside of those categories, then it just goes to the district court, and there's a dispute over which group this falls into. Now, cases were filed in district courts all across the country, and cases were also filed in courts of appeals. These courts of appeals challenges to the rule were consolidated into a single court under that provision. And many companies or industry groups filed in both places, filed both in the district court and the Court of Appeals, just to kind of cover their bases and protect themselves because there was this dispute over where these cases belonged. Now, in the district courts, so the Court of Appeals went ahead and consolidated these cases and was moving forward with the underlying issue of the challenge to the rule. In the district courts, some of the district courts dismissed the cases, saying that they did not belong in the district court and belonged in the Court of Appeals, and dismissed their cases. But others said that they did have authority to have these cases. They did belong in the district court, and they moved ahead with their cases. So in some cases, there were live actions involving the same parties in both the district court and the Court of Appeals at the same time. And someone's obviously wrong about where these cases belong, but there was disagreement over who it was. Now, so this brings us to the specific categories in the Clean Water Act that are carved out. And there was an argument that there were 2 categories that this Clean Water Rule could, the WOTUS rule could fit under. One category was for actions, a challenge to actions approving or promulgating any effluent limitation or other limitation. And the other category was an action issuing or denying a permit to discharge pollutants. Now, the government has argued in both cases that the WOTUS rule could fall under either of these 2 categories. They said as far as the effluent limitation category, they didn't argue that it was an effluent limitation, but they said it's an other limitation. They said by defining certain areas of land as parts of the waters of the United States, that was by pulling areas into that definition, that was causing them to be regulated and thus limiting the discharge of various substances into those waters. And on the issuing or denying permits side, the government said that basically this relates whether certain waters are covered under this WOTUS rule will determine whether or not the government will be issuing permits related to activities on those lands. The Supreme Court looked at both of those arguments and basically said no to the government, said no, each of these, the other limitation was not just talking about a definition that might pull things in. It was talking about things like technology requirements that would reduce pollution from certain types of industrial uses or things like that. And that a definition was just not a action limiting pollution. It was just defining the scope of the coverage of the act. And with the issuing and denying permits, they said, the same idea. They said that the text is clear. It's talking about when the EPA takes an action to issue a permit or denies an application for a permit, not just background rules that govern the law that applies. The government also had some kind of just broader policy arguments. They said that this is the type of rule of widespread national importance that should have the kind of uniformity that would be provided by being filed in the Court of Appeals and consolidated. This would provide these efficiency and uniformity benefits. And also, they said there was kind of an oddity to allowing a small, narrow issue about whether, for example, a particular company is denied a permit for one particular use, that would get to go straight to the Court of Appeals, while a broad challenge to a rule that affects everyone everywhere ends up down in the district court, where it's going to be, these challenges are going to be divided among numerous different district courts coming up through different courts of appeals. And they just said it just makes no sense to split things up like that. But the court decided, basically said, well, regardless of those policy arguments, that flies in the face of the actual language that was enacted. The Clean Water Act carved out these 7 particular categories. It could have easily been written much more broadly for all challenges to EPA action, but that's not what Congress did, and it doesn't fit in the categories. Therefore, it doesn't belong in the courts of appeals. Now, this was a unanimous opinion. It was written by Justice Sotomayor, and there were no concurrences or dissents. So basically, the court was unified in just saying, stick to the language of the statute. Its government was trying to stretch to fit this into those categories, and the court was not going to have it here. This is good in that it ends several years of battling in the district courts and circuit courts over this basic procedural question. There have, in some cases, been years of litigation just over what court this case belongs in, and not even getting to the merits, the substantive issue of whether there's a viable challenge to the rule that was enacted by the EPA. That there just, it illustrates the problems that can come when the procedural rules are unclear. Procedural rules are essential to have a functioning court system. People need to know where actions can be brought, how they are supposed to progress, what are the time limits for certain things, where appeals can be brought. These are essential features of a functioning court system. And when they're not clear, all kinds of delay and mischief and problems can result. So that's the basic summary of this opinion. There's one interesting little coda on this. In February of 2017, President Trump issued an executive order directing the EPA to rescind or revise the WOTUS rule, basically telling the EPA that it should look at the state of the law prior to the 2015 WOTUS rule and look to basically roll this rule back or otherwise revise it. Now, the EPA moved forward and eventually delayed the implementation of the WOTUS rule, but any final rescinding or revision or replacement of that rule is still in process. That's still an ongoing process right now. So the actual rule that's being challenged, by the time these challenges get resolved, it may be irrelevant. That rule may be gone, but for now, it's still live. That 2015 WOTUS rule is still the law that's in place, even though its implementation has been delayed. And in any event, regardless of whether that specific rule will be in place, it was important to sort out the proper way to place that court challenges to these rules should be filed, because it seems inevitable that whenever a new rule is in place or the 2015 rule is rescinded, there will likely be additional challenges filed to whatever the new rule is going forward, and it's litigants need to know where those will be filed. So this case kind of takes care of that problem, even if the specific rule being attacked may be irrelevant soon. So that's it for this episode. Please subscribe to Counting to Five on YouTube or your audio podcast app of choice. For timely coverage of the latest developments of the court, please check out Counting to Five's weekly YouTube live streams, where you can ask your own questions in the live chat. We're currently broadcasting Thursday nights at 9 p.m. Eastern Time, but check the Counting to Five YouTube channel for the next scheduled live stream. I'm always looking for feedback. Please leave a comment or send me an email at mike@countingto5.com. Thank you for listening. This has been Counting to Five.